Our second question. An anonymous sister, well, she asks to remain anonymous, as you'll see why. She has a very lengthy question, which I'll summarize. Apparently, she says that she got married to a man, and after she got married, she discovered that the man had an illegitimate child from a lady from before their marriage. Obviously, he was not married to that lady. And he, the father or her husband, still has a relationship with this child. He brings the child over every once in a while, and she was not informed of this child before the marriage, and now she feels uncomfortable, especially because the two of them have children and they have daughters, and she doesn't know, is this boy considered a mahram to her biological daughters, meaning this child is not from marriage, this child was from a relationship that was premarital intercourse, basically before they got married as well. And she's also asking, does that child have any financial right or inheritance rights over my husband, who is the father of my children? Should this boy be considered a part of my family or not?
وما أرسلنا من قبلك إلا رجالا نوحي إليهم فاسألوا أهل الذكر إن كنتم لا تعلمون.
Now, no doubt, I'm basing my answers on what you said, so I don't know his side of the story. If what you have said is true, no doubt, for you to not have been told is not something that is good. This is not information that he should have kept hidden from you, because, of course, while the marriage is valid, obviously it is not healthy to keep such secrets, because you are the life partner of this person. He has a child that is his, and also the fact that he was in an illegitimate relationship is something that you have the right to be affected by. Let me put it that way, right? And so it's not something that what he did was not right by not telling you. And you should have been made aware of the circumstances of this person and this child, and then make an informed decision. However, the fact that you were not told or not aware does not negate the validity of the marriage contract between you and your husband. So your marriage contract is valid, because whatever sin the man or the woman has done before the marriage does not, meaning sin of a sexual nature, it does not invalidate the marriage itself. And so the previous sins of a spouse with a third party or a child being born does not nullify the nikah that is taking place. But no doubt what the person has done is not something that is praiseworthy, and you have the right to feel irritated, and you have the right to express that irritation, and that he should make amends for whatever way possible. However, to move on to the more technical issue, this was the moral, if you like, outrage or whatnot. Now we get to the technical issue. This issue is multifaceted, and I'm going to give you generic rules. I do encourage you or your husband to go to a sheikh and a local sheikh and explain your situation, so that the sheikh can quiz you and get more details. Again, that's something that pretty much all the time, if there's a specific fatwa, go to a specific scholar, so that any type of exceptional circumstances can be taken care of. I can't do that in a generic Q&A, but I will give you generic knowledge about this issue of illegitimate children, because it is something that people need to know about, and we seek Allah's refuge and protection from ever having to deal with it ourselves. Do realize, by the way, that this issue of unwed children, or children born out of unwed marriages, this is one of the greatest dangers of intercourse outside of marriage, as it brings about children. It results in children who don't have stable families. And this is one of the main reasons, not the only one, not the primary, but one of the primary reasons why our religion has legislated sexuality, and that why it encourages sexuality only within marriage, and it forbids sexuality outside of marriage. We also need to know that the child of an unwed couple is absolutely blameless in all circumstances, and that never should such a child carry any blame or be made to feel guilty for what the parents have done. It is true that some books of Islamic fiqh, some books of law, some of them, they do say that the child born of such a marriage should not be the imam or should not be a person of power or dignity, but that is their cultural understanding of certain generic aspects of the Sharia. In reality, the Quran is explicit, وَلَا تَزِرُ وَازِرَةٌ وِزْرَ أُخْرَى, that no soul shall bear the sin of another. Whatever the parents might have done, the child is sinless. And it is not the fault of the child. The circumstances of the birth of the child have nothing to do with the honor and dignity of that child, and it is unbefitting and unbecoming and un-Islamic for anybody to diminish the honor of that child for something that the parent might have done. So we need to be very explicit and clear about this. The child deserves nothing but love and comfort, and no one should make the child feel uncomfortable. Anybody who does this is doing something that is sinful for the person that is doing it, and the child is free of any sin of the parents. The next issue is that the child that is born outside of wedlock, technically it does not take on the legal protections afforded by marriage. Now again, we have to differentiate between the moral status and the dignified status of the child, which is unblemished, versus the technical perks that come from being born in a marriage situation. That's something separate. And a child that is born outside of the wedlock does not take on any legal protection of a marriage, because there was no marriage. In fact, that's one of the purposes of marriage. Marriage brings about legal protection between the partners and for children born from that partnership. In Islamic law, the child takes on the name of the father, the financial responsibility is that of the father, the child inherits from the father is financially responsible for raising the child, etc., etc. However, if the child is born outside of the wedlock, then the default position is that there are no such protections, and therefore the child will not take the name of the child, of the father. The child will not inherit from the father, and we're going to come to this point again, but again, this is the default position, that the financial responsibility will not be on somebody who is not considered to be the legal father of the child. This is the default position. Now, if the woman is married and zina occurs with another man, that's something totally else. In this case, the child shall take on the name of the married husband, and any external affair will be ignored and neglected by anybody outside of the marriage situation. No one else has the right to interfere in a marriage situation. Even if modern tests are done or whatnot, it means nothing to us, because our laws are not necessarily the same as biological laws. That's a separate issue. Our sharia, our fiqh is not necessarily the same as biological DNA. So if there is a married couple and wal-iyadhu billah, we seek Allah's refuge, zina occurred, and the married lady gave birth to a child, and DNA later showed that this child is actually the son of so-and-so. From an Islamic perspective, we will ignore that, because our Prophet ﷺ said, Al-waladu lil-firash. The child is ascribed to the marriage or the bed that it was born upon. Al-waladu lil-firash. This is the rule of Islamic law. There's only one exception, and that is when the father himself, when the husband of this woman says, no, this child is not mine. And the husband then undertakes a particular process called li'an or mula'ana. We're not going to go down there. That's a technical thing between the husband and wife. The husband, and only the husband, has the right to say, I know this child is not mine. And then there is a procedure to be done. An outsider cannot and should not get involved. It's none of their business. And if the couple has passed on and modern DNA tests bring out about some other news and whatnot, this is all relegated to, the footnotes, and it doesn't affect anything. Technically, the child shall remain according to the marriage. So al-waladu lil-firash. A married lady who has a child, that child is ascribed to the marriage and not to any type of affair, illicit affair that might have occurred. Even if DNA shows to the contrary, that means nothing, because we want to just cover up anything that would have happened and provide dignity and sanctity to the marriage itself. However, if the lady were single, not married, and the father and mother of the child both agree and claim that this child is theirs, So this is now a couple, a boyfriend, girlfriend, a premarital couple, whatever. They are together for a while, and she's not a lady that's sleeping with multiple men, so doesn't know. No, she has been in an illicit relationship, but with one person. And the two of them, then they have the child, and then they claim, both of them, they say, this is our child, we know it's our child. Now, if they decide to get married, can we backtrack the marriage? The child is already born, clearly before the nikah. We're not talking about a gray area and within 7 months or something, less than 9 months, whatever. If it's 6 months after the nikah, no problem. But so the child that is born after the nikah, even by 6 months, inshallah, no problem, we don't ask. However, what if the child is clearly born and then the nikah takes place and the couple says, this is my child? So here we have a majority and a minority opinion. I hope this is a clear situation. Both man and woman are unmarried. The both of them committed zina with one another. And they both agree and claim that this child is mine. If there's disagreement or whatnot, then the whole situation falls apart. And they both decide to get married. So now they have a legitimate nikah and a child from an illegitimate relationship between the same two. The majority position, which is the default of the four madhabs, is that the child shall be considered illegitimate even if the marriage takes place. However, Ishaq ibn Rahweh and Shaykh al-Islam ibn Taymiyyah and Ibn al-Qayyim and many modern scholars, including my own teacher Shaykh ibn Uthaymeen, they argued quite forcefully that in this case, with all of these conditions, we shall backtrack the marriage. And we shall overlook that the child was born before the nikah, and we shall consider the child to be a legitimate child, name and inheritance and everything will be established. And this is the position that I also follow, and it is in line with the goals of the Sharia, where we want to cover up a sin and we don't want to criminalize the child, penalize the child. We want to cover up any sin and not make a big deal about it, and we want to protect the interests of the child and to not have any backlash about the two have repented clearly and they're trying to make amends, they're trying to get married together. They do get married together in this case, according to Ibn Taymiyyah and Ibn al-Qayyim and many modern scholars, that we extrapolate the nikah, if you like, and we simply claim the child to be a part of the basically a legitimate child from this union and from this marriage. However, the sister's case, the one that emailed me, this man had a child and did not ever marry the woman that he had the child with. So this does not apply to this case. So if he had married, or even if he gets married, a legitimate nikah, meaning not a fake one, a legitimate nikah, and the both of them, they know that this is their child. They were together for that period of time, and they both acknowledge this. According to Ibn Taymiyyah and many ulama, in this case, the child shall be considered a legitimate one, and we don't ask about their past. However, if there's no nikah, then there's nothing to extrapolate. So in your case, your husband did not engage in a nikah with this lady, and so you cannot extrapolate back to this. So the child is going to be considered basically, technically, legally not his. However, what does this mean when it comes to financial responsibility? So because the default position is that the father, the biological father, is not the legal father, and there shall be no inheritance, so those scholars said, likewise there shall be no maintenance. Okay, when there's no technical or legal linkage between this child and between the man who sired him, even if it's a biological father, so they said, just like there's no inheritance, and just like the child does not have to obey the father and whatnot, so too the father does not have to give financial support upon the child. And this is the default position of our earlier scholars. Now, doesn't have to does not mean that he should not. There's no doubt that he should, especially if the child is having difficulty being raised by the mother and her relatives. And here I want to just point out, and I always, when it comes to Islamic law, I do not view myself as, astaghfirullah, ever being independent of the giants who precede me. I always am a minor person in their shadows, and I never give a fatwa or a position that is unique and unprecedented in Islamic history. There are some areas that I don't mind exploring, some issues of Islamic theology, some issues of the seerah of the Prophet, some issues when it comes to the concept of, ulum al-Quran and ahruf and qira'ah. There are certain issues I don't mind being a little bit more, going out on a limb and being in a very minority, or maybe even bringing something new, and I will defend myself when I do that. But when it comes to Islamic law, I have always said that I am simply following giants, and I never break away from those giants. I don't consider myself to be qualified to practice ijtihad in Islamic law. However, I will simply point out that a group of modern scholars, and this is a modern opinion, are arguing that a person who engages in illegitimate intercourse with a lady, that person should be partially, if not fully, financially liable as well. And this is a modern opinion. And so I'm simply saying it's there. I'm not endorsing it because I don't feel qualified to endorse such a minority position, because it is only being argued by a group of modern Muslim ulama. In the classical position, I'm not aware of anybody who obligated upon the biological father the maintenance of the child. But this modern group of scholars, and they're writing in academic journals, these are people that are working in, especially scholars trained in fiqh who then work in courts of law in the modern world. They see things that sometimes people that are simply with their students and reading the blessed books, they don't necessarily sometimes see. And what they're arguing, and I've read a few articles to this point, or an article or two I should say, to this point, what they're arguing is that what happens is that the bulk of the burden is then placed on the woman, the financial burden. And yet the pleasure and the sin was shared by both the man and the woman. So why should the woman be burdened financially when the both of them are equally guilty? Or perhaps even the man is more guilty if he was the one who, wooed the lady, and, she didn't have experience with men, and he kept on promising and whatnot, and the both of them did a sin, no question about it, and then he just disappears and khalas, ghosts her or whatnot, and then she has to deal with the child in the aftermath. And so there is a modern position that why should the person not also have a financial obligation? So that is something that is a modern opinion. At the same time, I am simply telling you it's there. I cannot, because of my own limitations, I have to stick with the great giants and the established schools and madahib, and I will say that I am not aware of any pre-modern opinion that has obligated financial support upon the biological father. That having been said, no scholar ever prohibits this support, and it is definitely the morally correct thing to do. If the person acknowledges this child to be his own, then your husband, the fact that your husband is you say that helping the child and taking care of the child once in a while and giving money and whatnot, this is something that is the least that he should do, and there's no problem Islamically doing it. As I said, the issue is whether he's obligated to do it, whether it's wajib or not. No early scholar said it is wajib, but no scholar said it's haram or makruh either. If he wants to give money, he has the right to give money to whomever he wants, and there's no doubt that this child being a part of your husband's life and being taken care of financially is something that is noble overall. Even if the act itself was not noble, the sin was done, but why should that sin be perpetuated? Also, the final point here, and you asked about the issue of marriage, and you're worried that this boy is coming to your house and you have daughters from this marriage, and so is there mahramiyya or is there prohibition of marriage? And when it comes to this issue, the vast majority of scholars, the Hanbali position, the Maliki position, the Hanafi position, is that they say even if the child is illegitimate, still the marital rules and prohibitions will apply. Hence, if a father, if a male and a female engage in premarital intercourse, they have, let's say, a daughter, right? This lady, this girl, shall be prohibited for her biological father, and for all of the biological father's sons, and for the biological father's uncles. In other words, that girl or the boy, doesn't matter, it will be considered for the purpose of marriage, like a real child, like a legitimate child. Not for the purpose of nasab, of inheritance, of patrilineal descent. That, no, they said. But for the purpose of marriage, yes. And of course, there's one madhab that disagreed, and with our utmost respect for that great Qurashi Imam, even if الناس عيال عليه, but this issue we have to respectfully simply delegate to the footnotes and leave it as something to know but never to act upon. No, you just don't do this. Your biological daughter is a daughter for the sake of marital purposes, and you simply do not open this chapter or door, and you leave this position as a minority, never acted upon. The default position of the ummah, and alhamdulillah it is the vast majority position, is that a child born outside of marriage shall be considered a biological child for the purposes of marriage, for the purposes of what is allowed and isn't allowed. And therefore, this young boy that is coming to your house is haram for your daughters, because your daughters are also the children of the same man who fathered this boy. So they are his half-sisters when it comes to what? Marriage. They are not his half-sisters when it comes to the legal rights and privileges, when it comes to the last name, but they are those half-sisters, or I should say step-sisters, when it comes to the issue of marriage. And therefore there is no question, there cannot be any marriage between your daughters and between this boy. Likewise, you as well become haram for this boy, because he is, you're married to his father, and so there's no issue over there. I just want to point out though that this is the issue for marriage. Quite a number of ulama, including Ibn Qudama, they said that yes, marriage is haram, but still hijab should be observed, because we don't want to respect the sanctity of marriage by extrapolating it to situations outside of marriage. And so what they're basically saying is that they don't want to affirm a normal relationship because it wasn't a normal union. Nonetheless, the point is that that's a technicality about whether to wear or not. The main issue is that this child is not allowed ever to marry your daughters, and he should be told that your daughters are the children of your father, and he knows who his father is, as that your daughters are the children of his father, and he should know this, and he should view them as people that he can never marry. And this is the position of Islamic law as well. I want to conclude this by stating that I understand, sister, that clearly this has irritated you and you have every right to be irritated, but I advise you to allow your husband some leeway in showing love and in showing care for this child. It's not his fault. The fact that your husband is spending time with the child and spending money on it, I know that of course it will cause you some grief, because you would rather that he spends on your children and whatnot, but put yourself in the shoes of the child. As long as he's giving you your rights, giving your children and his children his rights, if he gives some time and some money to this child that was born outside of marriage, and inshallah it affects this child to grow up in somewhat of a stable environment, be a productive person, be a good Muslim, inshallah, expect your reward from Allah subhanahu wa ta'ala. I know it's difficult and awkward, and yes, he should have told you, but what has happened, and you being good to others, inshallah, they're going to be good back to you, and inshallah, Allah Azza wa Jal will reward you. And also, I know the child is not yours, but once again, it's not the child's fault, and for you to show as well some kindness and love and compassion, and again, just to bring the heart of the child close to, the family environment and whatnot, inshallah, you will get your reward in this, and in the end, Allah Azza wa Jal knows best. Until next time, Jazakumullah khair. Assalamu alaikum wa rahmatullahi wa barakatuh.
يا من أجبت دعاء نوح فانتصر وحملته في فلكك المشحون، يا من أحال النار حول خليله روحا وريحانا بقولك كن.